Permission to refer to the bench collectively as your honors and individually as your honor.
Yes, please.
May it please the court, this is the first speaker arguing on behalf of the appellants in the case before this honorable bench today. I shall be addressing the arguments pertaining to the first two issues, whereas my co-counsel will be addressing the arguments pertaining to the next two issues. If the bench is well versed with the facts of the case, counsel seeks permission to proceed with her submission.
What is your team code?
Team code 60 on. 6060 on.
Thank you.
May I proceed?
So you are dealing with
The first two issues. Yes, Your Honor. With regards to the first two issues, it is our position that firstly, the CCI was competent to pass the orders granting access to Orion AI and Mishra. And secondly, that the proceedings in case number 2 of 2026 were proper and that subsection 3 of the Competition Act is applicable in the present case. With regards to issue 1, I have two main sub-arguments. Firstly, that the CCI has the regulatory competence to pass the orders in question, and secondly, that the remedies are proportional. With regards to the first sub-argument, under Section 27 of the Competition Act, the CCI is empowered to pass cease and desist orders, impose penalties, and most importantly, pass any such other order or issue such directions as it may be. This power of the CCI to impose any other order is wide, and in the case of Kerala Film Exhibitors versus CCI, which is a 2025 Supreme Court judgment, it was held, and I quote, the only check is that it should be proportionate and should have nexus with the object sought to be achieved, namely, to punish the recalcitrant party and also ensure that the penalty acts as a debt. In the present case, it is necessary to give the CCI broad discretion in terms of what remedies are being imposed in the present case. The CCI needs to be empowered to deal with emerging technologies and the emerging anti-competitive challenges that it poses. And therefore, the remedies in question cannot be assailed on the grounds purely that they have not been granted before. The Council recognizes the fact that recently in the case of Ericsson versus Micromax, it was held that the CCI does not have the power to grant compulsory licensing of patents. However, Your Honours, please note that in the present case, Your Honour, I sense a question.
No, please proceed.
Much obliged, Your Honours. Your Honours, in the case in question, both Orion AI and Immunoclass are protected as trade secrets. There is no sector-specific regulation for trade secrets in Indonesia. There is no sector-specific regulator for the same who may be empowered to grant compulsory licensing of the technologies in question. And therefore, in light of the same, the CCI does have the jurisdiction to pass the remedies in question as it is both proportional and this power of the CCI has not been taken away by necessary implication. If Your Honours have no questions with regards to the first sub-argument, I shall now establish how the remedies in question are proportional.
No,
Explain that logic about the absence of a sectoral regulator dealing with trade secrets, therefore gives you jurisdiction to issue compulsory licensing. We're not following that train of thought.
Yes, Your Honours. My argument is not that the absence of a sector-specific regulation automatically gives you this power. The argument that I am advancing is the power is in section 27 subclause G. Now, if there was a sector-specific regulation, this broad power that is given to the CCI would have been curtailed to necessary implication, which is the logic that was underlying the judgment in Ericsson versus Micromax as well. Which is that yes, the CCI has broad discretion in terms of the remedies it can grant, but since we have a sector-specific regulator, that discretion is now reduced by necessary implication. However, in the present case, since there is no sector-specific regulator, that broad discretion remains. It is not being curtailed by a legislative act, by a separate legislation, and therefore, as long as the remedies are proportionate, the remedies in question cannot be set aside.
So taking that final part, that compulsory licensing over a trade secret looks like you're trying to apply patent jurisprudence to a trade secret. Do you have any jurisprudence factoring this in? Is there any judgment? Is there any other foreign country where they've applied a patent licensing provision to a trade secret and therefore deem it a proportionate response?
Your Honor, while there is no specific case that deals with compulsory licensing of trade secrets, the Trade Secrets Bill that has been proposed does have a section on compulsory licensing which indicates that compulsory licensing of trade secrets can take place.
Very well.
May I proceed? Much obliged, Your Honor.
Check on these two questions. I think 27G will have to be. I think 27G will have to be read in line with what's given in 27.1. Assuming for a moment your 27G argument is correct, how does this, what you've imposed as a penalty, have a proportionate basis case and
Yes, Your Honor. This brings me to the second argument that I'm proposing. The remedies in question are proportional because firstly, with respect to Orion AI, it is an essential facility. In the case of Mishra Rail Infrastructure versus Ministry of Railways, it was held that the essential facilities doctrine can be invoked if, firstly, it is technically feasible to provide access to the infrastructure. Secondly, there is impossibility in replicating the infrastructure in a reasonable period of time. And third, that there is a distinct possibility of lack of effective competition if such access is not granted. And in this situation, all of these criteria are being satisfied. Your Honor, Orion AI is largely impossible to duplicate as the amount of data that was used to build this infrastructure was collected over 50 years. And Astrians was able to collect this data because it has 70% market share in the market in question. There is no other competitor that is equally placed in terms of, let's say, the duration for which they have operated in Indonesia or the market share that they have that would allow them to have the comparable amount of data in question. Moreover,
there's a fallacy in that argument. The data that is collected and that is used is proprietary data, one. So they're allowed to use their own proprietary data to be able to manage their fortune, one. Two, on what basis are you saying there are entry barriers in the market and no other entity has been able to do it? Has there been a restriction to use this AI tool by anybody?
Your Honor, there have been restrictions with regards to how Orion AI is being used by the competitors. For example, there are speed throttling restrictions in terms of API integration of the same. And therefore, there are restrictions in terms of how it is used. The emphasis on the fact that 50 years of clinical data was used to build this is just to indicate that no other competitor can easily build up a comparable infrastructure.
That's the case for every entrant in the market today, right?
Your Honor, please note here that the market that we are talking about is drug target identification using AI. The fact that Orion AI, at least as far as the factual proposition indicates, is the only reasonable model through which you can carry it out. The fact that there is no other alternative technology with respect to AI specifically that is available in the market indicates that this technology with the same amount of efficiency cannot be easily replicated by any other competitor. Does that answer your honest question?
I have one question.
I have one question which is a slight tangent to what you were saying,
Yes, sir.
and perhaps more, for want of a better word, philosophical than directly legal. In the circumstances with which we are faced, where a drug has been developed at the cost of several $1 million or crores of rupees, should the CCI not be hesitant about doing backseat driving? Would I be correct in saying that an approach like this would throttle innovation, etc., etc.?
Your Honor, it is our position that this will not throttle innovation. We are not stopping the company from making profits. We are saying that the way in which it is going about doing the same is creating anti-competitive effects in the market. With respect to Indonesia specifically, the drug remains exorbitantly priced. The access to the same also remains limited as indicated in Section 3 of the factual proposition. However, even if the quantity restrictions are removed, the drugs can still remain to be exorbitantly priced. Please note that there is an agreement between PSA and Astrius which specifically sets a floor price that is significantly much more higher than cost of manufacturing that goes into the drug or necessary compared to the R&D cost that went into the same. Introducing such a restriction then becomes necessary because just removing quantity restrictions on the sale of the drug does not address the concerns relating to the price at which it is sold.
Comparative analysis between this drug and a prevention drug that will be made in the future.
Your Honours, unfortunately, the moot proposition does not give us sufficient information to do a comparative analysis to that. If Your Honours have no further questions with regards to the proportionality of the measures in question, Council seeks...
I just have a question.
Yes, sir.
There's a difference between proportionality and deterrence. And if you want to compute proportionality, it doesn't. Essential facilities doctrine is not proportional. It is a solution, but it doesn't speak of proportionality. How do you arrive at proportionality? It requires some degree of computation in order to understand what's proportional. And proportional to what? Is it proportional to gain? Is it proportional to harm? So how do you decide that?
Your Honours, with regards to the essential facilities doctrine and the proportionality of the measures with respect to ARI, our main concern is that since this is an essential facility, all competitors need to be provided access to the facility in question on equal terms. Then the measures in question that we are suggesting, that is removing speed restrictions, removing throttling restrictions, becomes proportional because it directly allows us to achieve the aim that we see, which is to allow competitors to also have equal access to the technology in question. In this way, the restriction becomes proportional. Then maybe it may be argued that, let's say, provisions such as API restriction might increase cybersecurity risks. However, the technology right now does allow AI providers to put into place, let's say, guardrails in question that allow us to protect against these risks as well. And therefore, the measures in question become proportional. Does that answer your honest question?
It's a static perspective of proportionality. It's not like that in an innovative industry. But please continue.
Apologies, Your Honor.
Okay, maybe I should use this one. Your version is a static perspective of what proportionality is. It's not dynamic in a way which is what is required for innovative industry. But please continue. We have
Yes, Your Honor. If I may just briefly address that aspect of dynamic and the measures need to be dynamic in question, that is the exact concern that we are addressing. We see that the market right now is changing. Companies are increasingly on AI to conduct their drug discovery timelines. And therefore, given the fact that the nature of the market itself is changing, then addressing and giving access to this AI infrastructure becomes all the more important. And therefore, the remedy in question is proportional and is keeping in mind the dynamic and changing nature of the market. If I may proceed with issue number 2.
On what basis do you come to the classification of essential facilities?
Your Honours, why INA is an essential facility? Your Honours, this is because A, the facility in question is largely impossible to duplicate. It is necessary for effective competition in the market for drug target identification using AI. And providing access to the same is technically possible by removing API integration restrictions. And therefore, it classifies or it satisfies the test for essential facilities.
But there is a definition of essential facilities as it stands. Europe has taken that.
Your Honours,
Europe has taken on essential facilities, and there is a definition to essential facilities.
indeed, Your Honours, the Council here is relying on the definition of essential facilities as given in Harsha Rail Infrastructure Ministry of Railways, which have set out these 3 criteria that the Council just mentioned.
There is a there is a condition in linkage as well that I has said in European Union based on the conditions of essential facilities. What you're describing need not come under essential facilities.
Council seeks an extension of 2 minutes to summarize the submissions with regards to issue number 2. Much obliged, Your Honours. With regards to issue number 2, I have 2 main sub-arguments. Firstly, that the proceedings in case number 2 of 2026 were proper. And secondly, that section 3, subsection 3 of the Competition Act is applicable in the present case. With regards to the first sub-argument, in the case of CCI versus City, which
that principles of natural justice do not apply at this stage. And therefore, the correctness of the proceedings on case number 2 of 2026 cannot be assailed on the grounds that PSA was not given a right to contest its impeachment, since this right itself does not exist at this stage. Furthermore, with regards to my second sub-argument, that is subsection 3 of the Competition Act applies here. Your Honours, this section applies to horizontal agreements between entities. In the case of Nagrik Chetna Manch versus Fortified Securities, it was explicitly held that it is the business activities of the parties in the relevant market rather than the business activities in general which are necessary when we see whether there is a horizontal agreement or a vertical agreement between the two parties.
So what's the relevant market?
Your Honours, in the present case, the relevant markets have been defined as drug discovery and manufacturing in Indonesia and development of drug tablets using AI in Indonesia.
So for the first relevant market, you're saying it's three.
Yes, Your Honours.
How is that three?
This is because if I may draw your attention to paragraph number 28 of the Moot proposition, it specifically says that both Astreus and PSA are required to manufacture the drug in question together and they are both distributing the drug together. And therefore, they both have presence in the market for drug manufacturing and distribution in question. And therefore, section 3 subclause 3 applies in the present case.
Different segments of the market. One is a developer, one is a manufacturer.
Your Honours, while Astreus also has presence in the invention market, specifically with regards to manufacturing of the drug and distribution of the drug, both of them are doing it together. If I may specifically read out paragraph 28, it says, under the JOA entered between Astreus and PSA, both parties would undertake to manufacture immediately. Furthermore, the provision also says, paragraph also says, and the parties are individually responsible for the sale of their respective share of the manufactured unit. This shows that both of them are
So you're reading
manufacturing.
both parties as a group. You're reading Astreus as a group and you're reading PSA as a group. There could be a possibility that Astreus has one entity that does the development and one entity that does
The manufacturing aspect.
So you're reading Astreus as a group.
Yes. Therefore, in the present case, they are in a horizontal agreement, and since the agreement in question directly determines sale prices and limits supply, the per se assumption of anti-competitiveness applies in the present case under section 3 subsection 3a and section 3 subsection 3b of the competition.
Just a bit confused.
Yes,
Do we use the term per se in the Competition Act?
Your
Or is it
Honours,
rule of reason?
no, Your
Or is it
Honours.
presumption?
We use the term that there is a presumption of adverse effect on competition that arises when there is a horizontal agreement between the two parties that satisfies the types of agreements mentioned under section 3 subsection.
I fail to understand why Party 1 got into an agreement with the CD. Can you please tell me why was there an agreement between these two?
Your Honours, in the present case, Astreus did not have sufficient manufacturing
Is it
capacity.
sufficient or it did not have it?
Your Honours, the proposition specifically does not mention whether it did not have manufacturing capacities at all. It does mention, however, in paragraph number 21, that Astreus is in the market for drug discovery and manufacturing markets. So clearly it does have the capacity to manufacture the drug in question. Presumably it was because the manufacturing capacities were not sufficient that it had to entail the help of PSAs.
So thank you for that question, sir. So does that not mean that there are four different markets?
No, Your Honours, because they're both still jointly manufacturing the drug in question. Let's say Astreus can only produce 100 quantities of the good in question, but it wants to produce 1,000. So now it enters into an agreement with PSA saying that, hey, I will mention 50 quantities of the good and the rest you do, and together we will sell this good together. The agreement now in question is still horizontal because they're both entities who are manufacturing the same good which is immunized. That satisfies your
How should that work? Assuming that your argument on 3.3 is correct, what about the proviso?
Your Honours, the proviso is also inapplicable in the present case because this proviso only applies to joint venture agreements that aim to create efficiency in the production, distribution of goods and services, etc. And this requirement is not satisfied. This is because if we look at the terms of the joint operations agreement, it sets a floor price which is much above the cost of manufacturing needed. Moreover, the price at which, or this floor price, does not vary irrespective of the quantity of goods sold. If the aim of the parties was to create efficiency in the market, there would presumably be some changes in the prices when I am ordering 1 unit of the good versus 1,000. But that is not the case here. That floor price, which is set up much above the necessary price to recoup your manufacturing costs, remains the same. And therefore, this indicates that the intention of the parties was not to create efficiencies in the market, but essentially to maintain and gain even more and more profit because there is no other competitor in the market. If that satisfies your order.
So you can take 2 more minutes to conclude it.
Yes, sir. With this, I conclude my submissions on issue 1 and issue 2. Even if your honors were to hold that the proviso to section 3 subsection 3 applies, please note that in the case of FICCI versus CCI, it was explicitly held that if you are an efficiency creating joint venture, it just said what it implies or what it means is that we won't assume that your agreement itself is per se anti-proprietary. So therefore, AAEC can still be established by a separate invoice. With this, I rest my arguments on issue 1 and issue 2. It was a pleasure arguing.
We didn't argue.
Excuse me, sir.
Greetings to the bench. May it please this honorable court. I am the second counsel appearing on behalf of the appellants, and I shall address the third and fourth issues framed by this honorable court for consideration. For the convenience of the court, I shall structure my submissions in the following manner. Firstly, I would argue on the maintainability of the repetition by establishing that due to the existence of an alternative efficacious remedy, the repetition was not maintainable in the first place. My second set of arguments would go on to establish the merits of the improved notification, wherein I would establish that it is intra-vires both the Constitution and the Federal Acts. My third link of the arguments would be to establish that both the acts can operate simultaneously and penalty can be imposed against actors under both these legislations. With your Honor's permission, I now seek to move to my first set of arguments. Much obliged. Your Honor, it is a settled position of law that the remedy under Article 226 of the Indian Constitution shall not be used to bypass the statutory framework that has been envisaged by the Parliament and will be used only in exceptional circumstances where the statutory remedy that is provided is not efficacious. The respondents in the present case were only served with a show cause notice in the second case and were served with an order in the first case. They had the remedy of challenging the show cause notice first before the CCI and thereafter appealing it before NCLAT under section 34.
But is that the case? Are they challenging the show cause notice or are they challenging the notification itself?
Your Honors, they are challenging the show cause notice based on impugning the validity of the notification. And I understand Your Honor's question on whether the tribunal is competent to adjudicate upon the validity of such notification or not. Thankfully, we are covered by a constitutional bench decision of the Honorable Supreme Court that was delivered in the case of L. Chandrakumar versus Union of India, wherein the court was faced with a similar set of questions that were raised by the parties, which is, firstly, whether the tribunal can adjudicate upon the constitutionality of a delegated legislation, and secondly, whether the tribunal can adjudicate on whether a breach of fundamental rights has happened or not. If I may refer your Honours to paragraph number 90 of that particular case, the court had held as follows, and I am quoting: it has been contended before us that the tribunals should not be allowed to adjudicate upon matters where bias of legislation is questioned. We do not agree with this proposition. This will allow the parties, and I am quoting, to raise frivolous constitutional questions, to directly approach the Honorable High Court and bypass the statutory authorities, thereby negating the entire purpose of creating these statutory authorities. The court then goes on to mention that even if challenges under Article 14, 15 and 21 were brought forward by the parties in, for instance, service law matters, the tribunals would be competent to adjudicate upon whether a breach of these fundamental rights has happened or not. Because of the presence of this binding judgment of the Honorable Supreme Court, this question is no longer open for adjudication.
Counsel, what's the meaning of efficacious remedy?
Your Honor, an efficacious remedy would mean that it is a remedy that satisfies the needs or demands.
So alternative is not the only condition, efficacious has to be there.
Indeed, indeed.
What are the conditions on which a party can proceed and file a petition under 226?
Your Honor, those conditions have been strictly circumscribed. For example, in the case of urban slab, wherein the court has said that there are 3 exceptional circumstances where the court may directly allow a petition under Article 226. That would be, for instance, where there is an allegation of violation of principles of natural justice in the sense that the tribunal is not fair, is biased, or where there is a breach of fundamental rights that the tribunal cannot address, or where there is a question to the bias of the parent legislation and not the delegated legislation in there. So, for instance, in the present case, the respondents are impugning the notification. Had they impugned the Digital Competition Act, which created the authority, which created the Competition Commission and allowed it to adjudicate upon such matters, the matter would have been directly admissible before the Honorable High Court.
So the argument you are canvassing is that a delegated authority can listen to the delegated legislation, the challenge of the delegated legislation.
Indeed, indeed. That is the position that was taken by the Honorable Supreme Court.
You are saying this is not one of those cases where it could have been entertained.
Indeed. I now proceed to the merits of the impugned notification to argue that it is inter-virus of the Constitution and the Patent Act. However, I have a preliminary contention here, which is that the
Notification has been issued by
the Central Government, Your Honor, under Section 51 of the Digital Competition Act. Can I refer the provision, Your Honor? The provision states as follows. Power of the central government to notify and amend schedules. The central government, in consultation with the Commission, may by amendment notify new services or alter or delete services mentioned in Schedule 1 to this Act, and so on. The only 2 conditions imposed upon each power.
Please read subsection.
Every alteration made by the central government under subsection 1 shall be made as soon as may be after it is made before each House of Parliament while it is in session for a total period of 30 days.
Was this done?
Your Honor, the Moot proposition is silent on this. It neither states that this was done nor that it was not done. The respondents have not raised the fact that this was not done either before the single bench or the division bench, and therefore it would not be open for them to raise this challenge at this point.
Was the consultation done with the Commission? Not sure.
Your Honor, again the Moot proposition is silent on that particular fact, and because the respondents have not raised this procedural issue, it cannot be raised at this stage of the Supreme Court. Your Honor, my preliminary question to this, the validity of the notification is that the respondents, being companies and not citizens, are not entitled to raise an Article 19 challenge before this Honorable Court. This has been held and settled in a catena of judgments, latest of them Ex Corporation versus Union of India by the Karnataka High Court, which relied on a lot of decisions of the Supreme Court, including Indo-China Stream Navigation versus ACC, wherein the court specifically held that any right under Article 19 is a citizen-centric and not person-centric right, and hence can only be challenged by a citizen of the country. Therefore, it is not open at a preliminary level for the respondents to challenge the bias of the Act on grounds of violating Article 19 of the Constitution. I now proceed to the merits. However, I would want to take your honors to page number 14 of the Moot proposition, which states the reasoning of the division bench when it was quashing the impugned notification. The division bench held, while it is imperative that markets function well and fairly, any legal development has to suit the market dynamics and foster a business-friendly environment in Indonesia. Now, the entire consideration that was based out of for the division bench decision was to ensure that there is a market-friendly situation in Indonesia, that we are promoting startups, that we are promoting innovation, which goes far beyond what the judicial ambit of inquiry ideally should be. These are matters of policy, matters of economic policy in particular, which are reserved for the ambit of the executive and the central government. judiciary cannot then sit in appeal on the validity of these economic policies. It has been settled that on such matters, the government has a higher margin of appreciation and a latitude for deciding what economic policy best fits the country. And therefore, this order of the division bench that impugned the notification on such policy grounds is invalid. Now I independently establish why the impugned notification was intra via the Parent Act and Article 14 and 19 of the Constitution. Your Honours, as established earlier, the only requirement to be complied with by the central government while amending the schedule was under section 51, which is to consult the commission and to lay it down for the parliament. It has not been argued by the respondents that either of these procedural requirements were not satisfied. Now, on merits, the only limitation is that such amendment has to be furthering the legislative objective of the Act. What is the legislative objective of the Digital Competition Act? It is given at page number 16, paragraph number 62 of our arguments. If your Honours may refer to page number 16 of the arguments advance, paragraph number 62, it states, the legislative objective of the IDCA is to foster innovation, promote competition, and protect the interest of users of such services, keeping in view the principles of contestability, fairness, and transparency. Now, by amending the schedule and introducing AI in healthcare as a core digital service, the only requirement that is imposed upon Asturias is to comply with the gatekeeper obligations so that the other competitors in the market are not barred from participating in this drug discovery using AI. And therefore, this particular notification furthers the objective of the IDCA. Now, coming to Article 14, it is a settled position of law that any classification that is reasonable, that is, it satisfies the twin test laid down in Anwar Ali Sarkar versus the state of West Bengal, would not be violative of Article 14 of the Constitution. The twin test is that there should be an intelligible differentia and there should be a rational nexus with the objective of that particular act. In the present case, there is an intelligible differentia that distinguishes AI in healthcare from AI in other sectors, which mandates that AI in healthcare be treated separately. The intelligible differentia lies in the fact that right to health is a part of right to life under Article 21 of the Indonesian Constitution, and that the Constitution mandates it upon the state to ensure affordable and accessible healthcare to all the citizens of the country. And this justifies, therefore, the imposition of extra obligations on the AI in healthcare sector. This also has very evidently a rational nexus to the objective of the government, which is to ensure affordability and accessibility of healthcare services to its constituents.
Counsel, by this logic, I can strip away intellectual property across many sectors. I can make it a right to education as a fundamental right. I have healthcare. What about training an AI model? Therefore, copyright does not apply because you need to train and deploy AI. This is a maximalist argument you are adopting.
Your Honours, would argue that the appropriate balance to be struck down between intellectual property rights and accessibility of individuals to the benefits of that innovation. The appropriate authority for deciding that is the central government and the elected parliament and not the judiciary. Only when there is a specific contravention of an article of the Constitution will the judiciary then step in to say that this particular contravention needs to be remedied. However, the right balance to be struck down between them should be left to the wisdom of the parliament. I would lastly establish that Article 19(1)(g) of the Constitution is not violated, as the freedom of business and trade is not absolute and can be subjected to restrictions on grounds enumerated under Article 19(6) of the Constitution, which requires two conditions to be satisfied. Firstly, the restriction must be reasonable, and secondly, the restriction must be in the interest of the general public. I would avoid reiterating why the restriction is in the interest of the general public, because the arguments for that are largely similar to the arguments under Article 14. The restrictions are reasonable because they satisfy the four-pronged reasonableness analysis, which requires a legitimacy of objective necessity, the objective being least restrictive measure, and the proportionality analysis to be satisfied. Since all of these conditions are satisfied in the present case, the impugned notification is intra vires both the Constitution and the Parent Act. I now proceed very briefly to my fourth issue, which is that both acts can operate simultaneously and that penalties can be levied against actors.
Page 74, page 70, sorry, paragraph 74, page 19 of your memo.
Thank you, Your Honor. I'm back. I believe.
No, so your argument seems to be that the legitimate objective of preventing players like so and so from establishing monopoly in the healthcare sector. There's nothing wrong with establishing monopoly. What is the object of digital competition in IDCA?
Your Honor, to foster innovation and competition in the market.
Correct. So nowhere does it say that you're prevented from establishing monopoly.
Your Honor, promoting competition would also mean ensuring that there are no market barriers that foreclose the entry of other entrants in the
How
market.
have you brought market barriers into this paragraph 1 of the notification? You simply say the notification reads a machine learning model that processes data to generate so and so in the healthcare, pharmaceutical and life science sector, which is likely to have significant impact on competition or public welfare.
Indeed, Your Honor.
That's what you're saying. And in your memorial you say that you want to prevent exorbitantly pricing essential medicines.
Indeed.
Is this an essential commodity under the Essential Commodities Act?
Your Honor, we do not mean essential medicine to be an essential commodity under the Essential Commodities Act. An essential medicine because this is the only life-saving medicine that has been discovered. I seek a brief extension of time to address the question. So essential medicine because this is the only known remedy for the disease that was named. And that is why it is essential and not essential under the meaning of the.
So you are not regulating the drug.
We are not regulating. We are not regulating the drug by means of that notification, Your Honor. We are regulating AI services that allow for discovery of drugs like that. I will briefly conclude with my submissions on the fourth issue, which is that simultaneous operation of all the acts is allowed. This is because, firstly, this has been the parliamentary intention as clear from section 45 of the Digital Competition Act.
Due to paucity of time, we understand even if you simultaneously apply the provisions for a similar instance, how do you justify the proportionality of taxing 10% and then additional 20% of global revenues? How do you justify the penalty application from a proportionality standpoint?
Your Honours, in the present case, the factual matrix is silent on the extent of the harm that happened in the market, and so we are constrained by that. The only fact that is given.
The whole case here is the extent of harm. So for damages computation, you're walking away from the extent of harm.
I apologize, Your Honours. So the only fact that has been raised by the respondents is that 10% of the global turnover is the highest punishment that could have been levied under the Act. Now, in the case of CCI versus Kerala Film Exhibitors, for example, the court specifically addressed this argument by the respondents to argue that merely because the maximum penalty imposable under the Act has been imposed does not mean that it was disproportionate.
This is a disingenuous argument. Your whole case here is it's a right to health, it's an essential service, my people are dying. The presumption of that monopoly will be that there's significant damage and harm, which is why you're standing before us and we've accepted your arguments. Now, if we take your arguments to the logical conclusion, there is significant harm. Significant harm will lead to significant damages. The statutory damages is prescribed. So now we are saying, assume for the purposes of this case that we are applying that 10% rule. Over and above that, I am maintaining a parallel cause of action. What is this hypothetical? The legislation is IDCA. Under IDCA, I am having another 20% tag on. There's a 10% under ICA, 20% under IDCA. How are you dealing with the double dipping?
Your Honours, under the IDCA, the penalty is 10% of the global turnover.
And the ICA?
ICA also 10%.
Right, so you're down at 20%.
Indeed.
Right, for a similar transaction and same cause of action, how are you justifying the proportionality of the double dip?
In addition to structural behavioral remedies.
Indeed.
Yes, because you adjusted the licensing terms as well.
Indeed. Your Honours, behavioral remedies are firstly prospective in nature, and so they do not address the harm that has been done already. How do we justify the imposition of dual penalties is by saying that the cause of action in the present case is not the same. So while it arises from the same factual matrix, the ingredients of violation under both the legislations are totally different, as when in the case of Sangeeta Ben Patel versus State of Gujarat. Now, because the ingredients of offences are different and there are two independent violations that have happened under two independent legislations, it will not be open to challenge the imposition of penalty on one basis.
Expand on that logic of how the ingredients are different.
Indeed.
Right?
So under the Competition Act, Your Honours, the ingredients of the offence are that the player should be having a dominant position in the market. It should have abused its dominant position in the market. That would lead to an anti-competitive effect on the market. Under the Digital Competition Act, on the other, the entire framework is different. The ingredients are different. Firstly, it requires you to be an SST. The gatekeeper obligations under section.
Offences that are there in the Competition Act.
Indeed, Your Honours, however, the procedure framework is different in the sense that the digital
perhaps, but you're still looking at an abuse of dominance from an ex ante and an ex post scenario under both the legislation.
Indeed. Now, the European Court of Justice, Your Honours, in a similar factual scenario where both the ordinary competition law and digital competition law were applied, held as follows. If I refer you to page number 20, paragraph number 79 of our argument. It laid down a conclusive criteria on what factors should be established to allow parallel imposition of penalties, paragraph number 79. It held that a party may be subjected to parallel proceedings under the DMA and the antitrust rules for the same conduct, where firstly, law provides for parallel proceedings which is satisfied in the present case as established by section 45 of Digital Competition Act and section 62 of the Competition Act. Secondly, the legislations pursue complementary aims, and thirdly, the principle of proportionality is safeguarded. We argue that they are squarely covered by this decision of the European Court of Justice, and because these three factors are satisfied in the present case, simultaneous penalties can be imposed for the same issue.
Given a behavioral and structural penalty as part of the Competition Act, which is a future act which the entity is supposed to follow, if there is a mismatch of that clause that you provided saying that you have to do 1, 2, 3, 4, 5 things as part of your behavioral and structural, if they don't follow, then you have a case for imposition of penalty. How are you imposing the penalty today?
Your Honour, section 28(1) of the Digital Competition Act allows the Competition Commission to impose penalties if there is a violation of section 17. Section 17 mandates the following of gatekeeper obligations as given from section 10 to 15. So our imposition of penalty in the present case is squarely covered under section 28(1) of the Digital Competition Act and therefore could not be found for.
Okay, so Mr. Counsel, in the end, if we accept your argument that these are different disputes, different remedies, so your penalty is justified. So that can't come to your mind ever that you are penalizing an entity which has come up with a formulation with the medicine of its kind, the only medicine available in the market, and you are imposing highest penalty, that too for under two different disputes.
No, Your Honour, we totally
yes. We also consider the thing that deterrence is must, but deterrence versus killing the enterprise.
Your Honour, no, we totally appreciate the innovative efforts of the respondents and we are not contending on that. However, if such considerations were to be taken by the court in mind, then the commission would not have, for instance, imposed huge penalties on WhatsApp, on Meta, because they have been huge facilitators of social media, of communication, of information technology. The impact that the company has had on the larger public and the benefit that it has given to the larger public is immaterial when it comes to the imposition of penalties on it under the legislation.
So if I might compel Supreme Court to consider decision of a tribunal that here this position was taken, so in this case also that should be confirmed.
No, indeed, Your Honours, the court is not bound by the decision of the Honourable Tribunal. However, we argue that at this stage, in the second case, only show cause notice has, for instance, been issued. Now it is not up to the Supreme Court, for instance, to at this stage intervene in the show cause notice and adjudicate on the proportionality of the penalty that has been imposed. And that the court has often left to the discretion of the regulator. and not interfered with unless it was found manifestly arbitrary. And so this Honorable Court sitting today should not, before the show cause notice has even been responded to, sit and adjudicate on the exact quantum of penalty that should have been imposed in the present case.
Do you have a reasoned argument to show that this collective penalty will not kill anyone?
Your Honors, the regulator has to balance between fostering.
Consider this. A firm, when it engages in R&D, has to amortize its costs. Have you considered the overall R&D expenses, amortization, and how your 20% will fit in this overall framework? And whether you just stop the company in its tracks, given that you're also doing behavioral review.
Your Honors, as my co-counsel argued, the remedies that are imposed on the respondents do not hamper the recoupment of research and development costs, because they are only asked to license the product to other competitors and are not asked to distribute it or give it to them for free. So the licensing fees should then be allowed to recoup the research and development costs that have been incurred by the respondents directly, and the regulator does not intend to therefore throttle on innovation or to shut shop for the respondents. The only intention of the regulator and its obligation is to ensure that it does not foreclose the market on its competitors and does not impose a monopoly on the market for drug discovery, therefore gaining the power that allows it to exorbitantly price drugs that are essential to the population.
So you're speaking of FRAND?
Indeed, Your Honors, that is.
FRAND apply in this case?
Your Honors, that is the behavioral remedy that was allowed by the Commission taken by one of the cases. Since any other question from Your Honors? Much obliged, Your Honors. Shall I recite it here or is it on record?
What if you remand the matter back for the High Court?
Your Honors, the writ petition value is not even maintainable, and so we would argue that the matter should be left as decided by the judiciary. Obliged, Your Honors, for the pleasure.
Permission to approach next. Greetings to the Honorable Bench. Greetings to the Honorable Bench. The Council seeks permission to address the bench collectively as your lordships. Much obliged. May it please the Court, I, along with my co-counsel, shall be representing the respondents in the present case, that is Astrius Life Science Private Limited and PSA Private Limited. I shall be addressing the first two issues in taking 15 minutes of this Court's time, whereas my co-counsel shall be addressing the later two issues in taking 14 minutes of this Court's time. We reserve 1 minute for rebuttals. If your lordships are well versed with the facts of the case, the Council would like to proceed directly to the issues. Much obliged, your lordships. Your lordships, in the light of the facts of the case, the first issue before this Honourable Court is whether it is within the regulatory competence of the CCI to pass orders granting access of Orion AI and Immunoplus. Your lordships has respectfully submitted that the Commission lacks the jurisdiction to mandate access to Orion AI or compel the licensing of Immunoplus under Section 27 of the Act. Your lordships, the impugned directions amount to an impermissible expansion of the powers of the Commission under Section 27 of the Endorsing Competition Act. The submissions in this regard shall be twofold. Firstly, that the powers under Section 27 are limited, and secondly, the order is not appropriate as the essential facilities doctrine principles are not satisfied. Your lordship, moving to the first prong of the Council submission, whenever Section 27 is attractive, the powers of the Commission are not unbound. They must be exercised in accordance
value from being kept a secret. In the present case, both Orion AI as well as Immunoplus are proprietary innovations that are not available in the public domain. They are developed through substantial.
Yes. So essentially, I find this a very circular logic. Why is the competition division seized of the matter originally? You have created a monopoly of sorts. And that monopoly, you try to get around patent laws by keeping it as a trade secret to continue your monopoly indefinitely. And now using that indefinite monopoly, you are appearing before us to say, because we are a trade secret, don't interfere, don't even modify the terms of the agreement. Why? Because we are a trade secret. And therefore, indefinite monopoly will continue. Do you see the circular logic to the presentation? How do you get around that?
Certainly.
And in fact, why shouldn't we just consider it as strategic behavior on your part?
Certainly. Your Lordships, coming to the first point that you pointed out, being a monopoly. Your Lordships, the monopoly will be established when we look at the market, the two markets that have been defined. Firstly, drug discovery and manufacturing, and secondly, development of drug targets using AI. Your Lordships, the submission from the Council is that the market that has been defined using AI is too narrow. Your Lordships, AI is merely a tool for the development of drugs. Therefore, a separate market specifically for AI is too narrow, and therefore this is artificial dominance that is trying to be proved. The market is uniform for all other R&D tools such as clinical trials, collaborative researches, etc. Therefore, AI should not be treated as a separate market for development of drugs. Your Lordships, development of drugs using research methodologies. There's nothing particularly specifically for AI because again AI is merely a tool for development of drugs and it cannot solely be just one tool that may constitute an entirely different market.
So assuming that your market definition can be accepted, you find that you are not dominant in that market?
Certainly, Your Lordships, because the facts again are silent as to what are the conditions in that particular market, because the market that has been identified by the DG is that of the AI and not in particular for the general drug discovery using tools.
Okay, and assuming, my brother that is going to ask this question, but assuming that trade secrets are not regulated, can the CCI not make structural changes to your transaction? Your transaction is that of a contract between you and the other entity.
Certainly.
So can the CCI not make transactional changes?
Definitely, Your Lordship, the CCI does have the power to make structural changes. But then in this particular appeal, we are only questioning the order in regards to the access of Immunoplus and Orion AI. The structural alteration that Your Lordships are talking about is in case number 2, which is not being challenged in this regard as to the powers of the CCI under section 27. The powers under section 27G, that is to pass any other order as the CCI may deem fit, is the one that is being challenged because it is not unbounded in nature. There must be a restriction as to the limit or extent of the orders that can be passed under that section, particular clause of that section.
So where is that jurisprudence coming from? So we accept it in principle that there should be a restriction. Where is it? And you can ask the council to stop shaking your head for a comment from the bench. You can relax that. So the question is, we appreciate the line of argument. There should be some restriction. But you're also making the point that trade secrets is an entirely different branch of law and not subject to restriction. So where is the balance in that argument?
Certainly, Your Lordship. Your Lordships, assuming that any order can be passed with regard to trade secrets under section 27, the second test that the councils are trying to put forward is that of the essential facility doctrine. Your Lordships, access can only be mandated in very special and stringent circumstances where all the 4 conditions of the essential facility doctrine are being met. Your Lordships, the 4 conditions that have been laid down in the case of IMS Health versus NDC Health and also the case of Oscar Bronner versus Media Print are being, firstly, the factor of indispensability, secondly, the factor that the refusal should eliminate all competition in the secondary market, thirdly, that there must be a new product that has to be created out of the access that is provided, and lastly, the refusal to access must be objectively justified. With Your Lordship's permission, the council would like to prove how each of these factors are not fulfilled in order to maintain that the essential facility doctrine is
discovery methods? Are they comparable in terms of speed, in terms of cost, in terms of efficiency? And secondly, you're bringing in potential competition from the future. Do you have any reasonable basis to say that there can be something that can come up, or you're hypotheticating just that something could happen? Anything could happen. Tomorrow we could all be dead. Right? So drastic, but I'm just saying. So that's a wild one. We should have some basis for both these arguments.
Certainly, Your Lordship, the answer to that question shall be two-pronged as you raised two contentions. Firstly, talking about other tools and how are they comparable. If Your Lordship will please refer to paragraph 102 of the compendium that we have submitted, the first condition is explained. Each of these conditions are explained in this judgment. The counsel would like to quote, for a product or service to be indispensable, it must be determined whether alternative products or services exist even if they are less advantageous. As Your Lordship mentioned that AI is a competitive edge in terms of time or also the data sets. But the other tools, even though less advantageous, does not mean that there exists no substitute viable for development of drugs in the market. Therefore, the indispensability factor stands satisfied. Your Lordship's talking
about... But can you include them in the same market?
Certainly, Your Lordship, as stated by the counsel, that all of them are just tools for drug development and therefore they can be integrated into a common market for tools for drug development.
Okay. Maruti Alto is a tool and so is a Mercedes-Benz. Are they in the same market?
No, Your Lordship, that is a Your Lordship,
they're both same tools, they take you from A to B.
Certainly. But they are distinguished in terms of different components. One is the luxury market and the other. So there is a distinguished.
So your AI is a luxury discovery platform and the other one is an ordinary discovery platform.
Your Lordship, the counsel would beg to disagree. AI is not a luxury platform. It merely is a more advantageous platform. But that does not simply mean that it's more advantageous. That doesn't mean that there are no substitutes. It will always exist that one thing is better than the other, but that doesn't.
How do you arrive at substitutes? What are the conditions for relevant product market?
Certainly, Your Lordship. Your Lordship, Section 19 of the Act provides for.
You have 96 and 97.
For Orion AI or.
No, I'm talking about Orion AI 2. You have product market characteristics. You have to satisfy certain characteristics.
Certainly, Your Lordship.
Is one of the characteristics end use by a consumer?
Certainly.
So are you going to say, and since we're all lawyers here, are you going to say that Manupatra is equivalent to a Claude or a Google Gemini?
No, Your Lordship, and as to why that is, because both Manupatra and Claude, let's say, are being used by the ultimate consumers, and the output and the devices have different, they are used for different purposes. Claude AI is a tool for, let's say, research and other writing, enhancement, etc., etc. Certainly, Your Lordship. But again, in characteristics, they differ completely. One uses a system for, one uses data sets, and the other is just.
Manupatra also uses data sets. Claude also uses data sets.
Certainly, Your Lordship. But Manupatra, then itself, districts itself is just legal searches, but Claude and AI are more advanced than that. They just do not.
It's a very restrictive meaning you're giving. Anyway, proceed.
Certainly, Your Lordship. Your Lordship, the second test of the essential facility doctrine that the counsel would like to bring your attention to is the test of the new product that must be created with the access. So what this condition essentially means is that once access is provided, the access that has been provided must lead to a new product for which consumer demand exists. Now, Your Lordship, and also that the product should not already be introduced by the existing intellectual property holder. Your Lordship, how this condition is not fulfilled is by granting access to Immunoplus. Ultimately, the compound that will be produced will be a different variety, let's say, of Immunoplus. Because to make a viable
You have access to everything. What is the big secret? Can you suggest one document that would materially impact your case, your co-developers, your co-manufacturers? Yes.
Certainly, Your Lordship, the Council agrees to that fact. But having not provided that the reliance was placed on the joint operations agreement, it is only speculative of PSA to assume that the reliance was placed on the joint operations agreement, because the JOA in the commitment application was an additional document that formed a part of the commitment application as clearly stated in the Moot proposition itself. Now, connecting the annexures or the supporting documents were not provided at all. Therefore, it is only for PSA to assume on which basis of the documents were the engagement based on. Therefore, Your Lordship, this is a procedural impropriety that has been found.
Due to paucity of time, address the second issue of why this is not a horizontal agreement. And when you start, see the title of your joint venture. It's not a joint venture, it's not a subcontracting agreement, it is specifically joint operations. And also address the fact that the fact problem company also mentions that you're both manufacturers and then proceed with the agreement.
Definitely, Your Lordship. Your Lordship, the Council's contention in this regard, the non-applicability of Section 3.3 are threefold. Firstly, the presence of a downstream competition does not automatically render the joint operations agreement as a horizontal agreement. Secondly, the ancillary restraints doctrine applies in this present case. And lastly, the joint operations agreement produces pro-competitive effects in the market. Your Lordship, moving to the first prong of this submission, the assessment of any joint operations agreement must be based on the economic context and the commercial purpose for which the arrangement takes place. If Your Lordships may please refer to paragraph 27 of the Moot proposition, Your Lordships, it clearly states the purpose for which the agreement was taking place. Third line from the bottom, Your Lordships, Astris entered into a joint operations agreement with PSA for manufacturing the drug Immunoplus due to PSA's large manufacturing capabilities. Therefore, the intention of the joint operations agreement, PSA is an Indonesian drug manufacturing company that contracts with larger pharmaceutical companies to manufacture drugs in accordance with the specifications provided by those companies.
Because they are a drug manufacturing company, there is a subsequent segment and therefore there is a 3-4.
No, Your Lordships. There is no 3-4 and the Council also argues that there is no 3-3 as well. The Council humbly submits that they do enter into a cooperation, but the objective of that cooperation is for the increment of the manufacturing capacity of the ultimate drug that is being produced. Now, with that cooperation is an ancillary restraint that is attached to it. The ancillary restraint being the floor price that is being put by Astris. Your Lordships, the guidelines and the applicability of Article 101.
Are you not relying that it is a vertical agreement? Is that not at all your position? You're just not, even if it is to your benefit, you're not taking that interpretation.
No, Your Lordships, it's not a vertical agreement. Much of it. Your Lordships, the guidelines and the applicability of Article 101 of the TFEO to horizontal cooperation agreements, guideline 1.2.6 states clearly that restrictions those are objectively necessary to implement the cooperation and is proportionate to the objectives of the cooperation may be allowed, and they are called ancillary restraints. Therefore, Your Lordships, the contention of the Council being that the cost of manufacturing set aside, there is also a cost of research and development that has been incurred by Astris for the clinical trials, AI development, etc. And in order to recoup all of those costs, it is essential to put a floor price in order to maintain the prices in the market, Your Lordships.
So, to support your argument that this is a case where two entities are being investigated or have been investigated, which are neither related under Section 3.3 nor Section 3.4, do you have some precedents to argue? That in your knowledge, there are any other cases where parties have been investigated and they put this argument that our relationship is neither kind of 3.3 nor kind of 3.4?
Certainly, Your Lordships, the contention being that the essentials of section 3.3 as well as section 3.4 are not being met. Therefore, why would the counsel for the respondents go ahead and tell themselves that we are
Section 3.1.
any agreement having any appreciable adverse effect? But you know, also that is for the contention of the council that there are no appreciable adverse effects, rather it is producing pro-competitive effects.
So therefore, what are the efficiencies of this joint venture agreement?
Certainly, Your Lordships. Under 19.3, if you look at the factors, the latter three factors, namely being the benefit to the consumers, firstly. Secondly, improvement in production or distribution of goods or provisions of service. And lastly, promotion of technical and scientific and economic development by means of production innovations. These factors are producing pro-competitive effects. Therefore, the
93 is not applicable to you. So why would 93 be applicable?
in argument to Your Lordships, if Your Lordships still contend that there is a horizontal agreement, then there is pro-competitive factors of section 3.3 that puts this.
But the Moot problem doesn't record any pro-competitive effects of the joint venture agreement. How do you substantiate that?
Certainly, Your Lordship, with the facts of the case, the council can appreciate that pro-competitive effects are being placed in this particular joint operations agreement.
Appreciate it.
Can you please explain your client's entire agreement purpose? Why does it get into distribution of 70-30? Couldn't you have an alternate payment model for the CDMO? Why this particular model, 70-30?
Certainly, Your Lordships, it comes with the same reason that the cost that has been incurred by Astrius must be recouped. And also, Astrius is vertically integrated, so also present in the upstream market of innovation. And therefore, it must be able to recoup all of those costs. And therefore, the parties
that's not the point. There's a 70-30 distribution, which asks the CDMO, you take 30% of the production and you sell it, but you don't sell it below the floor price.
Certainly.
Why all that arrangement? Why can't you just say we give you 30% of it?
Certainly, Your Lordships. Your Lordship, the nature of the agreement is such that PSA, although being a contract manufacturer, is also definitely wants to sell the drugs in the distribution market. Therefore, even though they are competitors, they are dividing their total output in such a manner so that both of them can.
So you're dividing the geographic market?
No, not the geographic market, just the total production. We're not limiting the production as well. Whatever the total output has been produced, we're just putting it in a 70-30 ratio.
That characteristic of 3.3?
No, Your Lordships. The council disagrees that it falls under any of the factors of section 3.
Isn't there an equivalent way of compensation rather than this kind of division of the product sales mechanism which leads to this price independence?
Your Lordships, the objective of Astrius was to recoup their prices, and even though assuming that there might exist an alternative mechanism, this mechanism as well is very well not violating any of the
There
provisions.
should be an economic justification for this kind of an agreement. Serves a great purpose. So I'm not seeing that. That's
Certainly. Your Lordship, just the council would like to add that the clause is not also eliminating price competition completely as well. Because above the floor price, both the parties are free to choose their own prices and put a price whichever they deem fit. But the floor price is just set in order for Astrius to recoup its investment and not letting PSA sell a product that was innovated by Astrius at a lower price than Astrius in order to because of course PSA is only incurring the cost of manufacturing, whereas Astrius is incurring both the cost of manufacturing as well as the R&D that is happening.
Yeah, it's already your Salafian fallacy. The floor price is already the monopoly price. You price above that, you're not going to get it.
Certainly, Your Lordships, but it was a strategic decision of Astrius to enter in such kind of an agreement so as to recoup its investment. Much obliged, Your Lordships. According to Your Lordships, the proceedings stand initiated by procedural impropriety, and in any event, the joint operations agreement does not fall within the ambit of section 3.3 as it reflects a legitimate collaboration producing pro-competitive effects between Astrius companies. Much obliged, Your Lordships. It is the honor of submitting all this argument.
Greetings to the bench. If the bench is satisfied with the arguments for the first two issues, the Council seeks permission to proceed with issue 3 as to whether the writ petition filed before the High Court was maintainable and whether the impugned notification is unconstitutional. Much obliged, Your Lordship. The submissions under this issue will be made in...
What is your counter to their argument of and that you will address this before the tribunal?
Certainly, Your Lordship. To that, firstly, to the question of whether there is an alternative efficacious remedy. Firstly, there is no alternative efficacious remedy when it comes to a writ jurisdiction. A writ jurisdiction or a writ petition is always applicable before a High Court under Article 126 on
If you had a problem with the notification, you can take that up before the appellate authority or the tribunal.
Certainly, Your Lordship. I misjudged the question which was placed for me, Your Lordship. Apologies for this. In order to answer to that judgment, in order to answer to that question, Your Lordships, the Council places reliance on the judgment of Radha Krishna Industries versus the state of Himachal Pradesh, which is at page number 105, para 19.2 of the compendium which was submitted. Your Lordships, in this particular case, it was clearly ruled that the writ jurisdiction of High Courts is exercised in circumstances where the fundamental rights are said to be violated or where the challenge made is to the constitutional bias of the legislation. In this particular case, in and of itself, Your Lordship, if you could kindly come to para 47 at page 15 of the Moot proposition once, Your Lordship, Astrius exactly condemns this. Not only is there a violation which is being contended on the part of Astrius, but also the violence of the legislation is being contended. Henceforth, the writ petition is maintainable before the High Court, Your Lordships.
How are you claiming a fundamental rights violation, especially considering your complex nature?
Your Lordship, if I refer to Article 14, Article 14 applies to juristic persons as well, and henceforth, Astrius being a juristic person has a right under Article 14 and henceforth under the fundamental right, Your Lordship.
Explain some of the jurisprudence behind that. What is the judgment extending it to your corporate personality?
Certainly, Your Lordship. Your Lordship.
Does every company? Yes.
Certainly, Your Lordship. Your Lordship, for this particular question, the Council places reliance on the judgment of Whirlpool Corporation versus the Registrar of Trademarks. In this particular issue, it was upheld that whenever there is an Article 14 violation taking place and there is a writ petition upheld, the interest of the company then, or the company is also then represented in such an issue because there is an indirect representation of the members of the company which are also taken into consideration. In the sense, the members include the directors, the shareholders, as well as the promoters. In such unique circumstances, wherein the interests of these members are violated, Article 14 will be then applicable, Your Lordship. And it will
complete the logic there. How does this apply to your intellectual property case? And how are you making an Article 14 argument?
How are you bringing 14 into this equality?
Certainly, Your Lordships. Moving to Article 14, Your Lordships, it is humbly submitted that Article 14 has a twin test that needs to be fulfilled, that is of intelligible differential and rational nexus. Your Lordships, the CCI had recently conducted a market study on AI, and it noted that the competitive implications of AI are not inherent to the technology, but are dependent on various external context-specific factors like the market structure. Therefore, Your Lordships, the mere use of AI cannot therefore justify an inclusion within a larger regulatory framework designed for digital gatekeepers. Your Lordships,
very simple question. What is your Article 14 argument for an AI use case study?
Certainly, Your Lordships.
14, sorry to interrupt you. 14 talks about unequals being treated as equals, right?
Certainly, Your Lordship. Your Lordship, the first argument is of intelligible differential. This particular inclusion is taking place in Schedule 1, which is 9 core digital services. All of these 9 core digital services are present in matured sectors. These matured sectors have certain characteristics like an entrenched market power, the presence of entrenched market power. There is a presence of stable structure, and there is a presence of demonstrable control. These three factors were kept in mind when the ITCA was first promulgated, and this I am referring to the 25th Standing Committee report of the Lok Sabha in their Financial Committee, the report which was published by the PRS. This was the reason why these particular 9 core digital services were included in the first schedule. All of these reasons, your lordships, does not apply to AI in the first place. The reason behind the same is fairly simple. Your lordships, in the fact of Indonesia, it is still a market of experimentation wherein there is an entry of new players taking place and there is some amount of technological uncertainty in the market of generative AI. The same can be seen in para 17 and para 18 of the Moot proposition, that both traditional AI and generative AI is rapidly developing and there is shifting taking place in the technology. Henceforth, the precondition of intelligible differentia is therefore not satisfied, your lordships. If I have satisfied your lordships with respect to intelligible differentia.
So, before you come to intelligent differential, you will have to say there is A and there is B. A is being treated differently from B. The answer to that can be, one of the answers to that can be, we are treating A differently from B based on intelligent differential. Am I right? Can you correct me if I'm
Certainly.
That part of your argument I am not getting. What is the discrimination here since you are relying so strongly on Article 14?
Your lordship, the reasons which I had taken for intelligible differentia was, I placed before the lordships the very reasons why these 9 core digital services were included. Since these were mature markets and henceforth ex-ante obligations were required. And this was the Standing Committee report which looked into the justification behind these inclusions. Therefore, this gives us the ground based on which the differences were made in the first instance. Now, when the second inclusion is taking place, this particular intelligible differential does not exist. And the reason behind the same is because the market of AI in and of itself does not characterize the same features which exist in those mature marketplaces or sectors, your lordships.
This is a specious argument. AI is AI. You're talking about the maturity of the market. I can have an app in USA and deploy it all over the world, and now I have now India is now a mature market. So the way you're distinguishing the factor is Indonesia is a developing market, therefore AI is not that sophisticated, therefore do not regulate it with this specific regulation. This seems a flimsy argument because AI by its nature is global. I can deploy it globally, I can license it globally, and it automatically becomes a mature market.
I would add on to my argument, your lordships. The focus here is on the inclusion which has been made in AI as healthcare. AI especially in healthcare. Your lordship, this is the very contention of the council here is that the council agrees to the argument given by your lordship that AI has a huge role to play when it comes to market, when it comes to consumers at large. And even when we look at these particular 9 services and AI at large, the AI which is referred by my lordships here is that of AI which has an intermediary role to play, which means AI has a direct impact on the actions which are taken by the consumers. The same was noted in the case of Microsoft Copilot, wherein the very results which were shown by Microsoft Copilot automatically affected the actions of the consumers. In this particular case, in this particular stratum of facts, your lordship, AI is being used as a mere R&D tool for Astrius or for other business entities within this market space of healthcare. Therefore, your lordships, this particular differentiation is invalid.
So, I have one very, very basic fundamental question. If you had a problem with the notification and the newly inserted CDS, why did you classify voluntarily under SSP?
Your lordships, to that, firstly, the doctrine of, in this particular line of argumentation, the doctrine of estoppel is what is then applied to us. But whenever it comes to fundamental rights, your lordships, or constitutional rights for the matter, as ruled in the case of Olga Dennis versus the Bombay Municipal Corporation, at no point in time can fundamental rights or constitutional rights be waived off. Therefore, even if we have
fundamental rights have been violated after you classify yourself as an SSP.
Your Lordships, the moment we self-notified, we came under the regulatory ambit of the ITCA. That means the same regulations which are applicable under Chapter 4, the same obligations are now applicable to us. That automatically violated our right to trade as well as the Article 14, the right to equality violation which is taking place. Now, the right to equality violation, as I have mentioned, that this entire sector of AI in healthcare is a very nascent sector, Your Lordship. It is still developing in the sphere of negotia and has not matured to be of the same level as that of the other 9 digital services which have been already incorporated in the Act. Therefore, this differentia automatically affects those competitors who are actively participating in this particular sector and is therefore affecting our right to equality.
So your argument is that they should wait till your market is mature, then classify it as a CD.
Not necessarily, Your Lordship, that the market is mature, but rather there are certain benchmarks which are then established. At the current point in time, there are no benchmarks or there are no...
Wait for another 10 years, let the benchmarks set themselves and then we classify them as a CD.
Certainly, Your Lordships.
And how does it affect 19?
Your Lordships, for Article 19 states that reasonable restrictions may be imposed on the right to trade and the profession of a particular entity. Now, even though we admit the fact that there have been most of judgments where companies or corporate entities have not fallen under the ambit of Article 19. However, given the fact that whenever there is such a wide impacting amendment, the right of consumers as well as the right of business users are automatically affected in the very first place. In this regard, as I have earlier mentioned, Your Lordship, that the AI sector in Indonesia is a nascent and evolving market and therefore is in its formative stages of growth as well as in innovation. In such a sector, Your Lordship, the imposition of stringent ex-ante obligations which IDCA aims to impose for the mature sectors would be an overreach of the sanctions or overreach of the restrictions which are for those mature sectors, and hence would stifle innovation and development in the larger field of AI in healthcare, Your Lordship.
That's why he asked you what he did previously. Do you think we should wait for 10 years and keep coming back to the same thing?
Your Lordship, if not...
He asked you the question on the break.
Your Lordship, if not wait for 10 years, what the council suggests is that this particular inclusion is too narrowly defined. AI in healthcare is too narrowly defined, Your Lordship. If it was just artificial intelligence, it would have been more apt, Your Lordship.
It's a different issue. It's not rushed to be said.
Certainly, Your Lordships, but the council holds that the narrow restriction then allows the healthcare market to be also affected because of the use of AI. And that we feel, Your Lordships, is affecting the consumer's interest and the consumer's rights as well. Given the fact that healthcare, when is synthesized with a catalytic tool like that of artificial intelligence, can reap the benefits out of the same. Your Lordship.
Due to paucity of time, we wanted to address this next issue. You can proceed to your next issue.
Much obliged, Your Lordships. It is submitted that parallel proceedings against Astrius under the ITCA and the ICA for the same transaction, along with the penalties under the both statutes, are permissible in law. The contextions under this issue will be threefold. Firstly, the fulfillment of the principle of levis in idem. Secondly, preconditions permitting parallel proceedings not being satisfied. And lastly, with regards to the disproportionate nature of penalties being levied under the two acts. Moving to the first limb of my submissions, the Council will place reliance on the principle of levis in idem. The principle of levis in idem is parallel and runs similar to Article 20, Clause 2's principle of double jeopardy, which is present. The Council seeks permits. Article 20, Clause 2 of the Indian Constitution talks about the principle of double jeopardy, whereas on the other hand, Article 50 of the Charter of the European Union also talks about the principle nebis in idem.
In a criminal jurisprudence concept.
Your Lordships, I will be getting to that regarding the nature of criminal proceedings. Now, Your Lordships, the very reason why, on a preliminary level, the Council also clarified that the very reason why we have picked up the principle of nebis in idem is because this is the first application in Indonesia that two particular acts have been imposed on the same conduct, especially in an antitrust framework. The only parallel corollary jurisprudence for the same is the EU jurisprudence and the UK jurisprudence. Henceforth, the principle of nebis in idem is used. Now, answering your question, Your Lordship, regarding the point of whether it is a criminal proceeding, the Council places reliance on the judgment of D post SA, which is a CJEU judgment, which clarifies explicitly this under the principle of nebis in idem. Under the principle of nebis in idem, there was earlier this requisite of same criminal offence or a same offence. This was called idem criminal. In this particular case, Your Lordships, it was ruled that whenever we are analysing idem criminal or same offence, it necessarily need not be a criminal offence, given to the fact that antitrust framework works as civil remedies and behavioural remedies firstly, and secondly, idem criminal was dispensed of, and rather the inquiry would be whether same material conduct and the same substratum of facts has led to parallel proceedings or not. If same substratum of facts has led to parallel proceedings, then parallel proceedings will not be allowed.
What about the scenario of same fact pattern arising to two different set of harms? Does your logic still hold good?
Certainly, Your Lordships. To that, the same B post SA judgment and one more judgment, Your Lordships, of the CJU as well. It has been mentioned in the compendium, Your Lordships, if you could refer to the compendium. It was the judgment of Nord Zucker. In both of these judgments, Your Lordships, two particular preconditions have to be fulfilled. Now,
I'll ask you a more direct question. We'll take your own European jurisprudence here. Let's deal with the case from Apple to Meta to Microsoft. You both under antitrust legislation will be prosecuted. You'll be prosecuted under privacy legislation as well as the Digital Markets Act. So I can maintain not two proceedings but triple proceedings against you, right? By your own European jurisprudence.
Certainly.
So how are you using that jurisprudence here now?
Certainly, Your Lordships. For that, three preconditions have to be fulfilled, Your Lordships, all together at the same time, and even if one of them is not fulfilled, then parallel proceedings are not allowed. The three prerequisites are complementarity.
Where are you drawing these three prerequisites?
The B post SA judgment. If I could.
What is this SA judgment? What is the
B post SA judgment is a judgment.
Which court?
The CJEU. If I could, I've mentioned in the compendium, Your Lordship. So, in this particular case, all these three factors have to be fulfilled together. The very reason why both Meta as well as Apple were brought under the DMA's application as well as the DFU's application and they were penalized for the same was because all these three factors were applicable to them concurrently. In this particular case, Your Lordships, two of these factors are not applicable. Firstly, the point of foreseeability and secondly, the point of proportionality. I'll firstly move to the point of foreseeability, Your Lordships. Your Lordships, in the present case, this threshold is not met on two distinct grounds. Firstly, that the IDCA, that is the Digital Competition Act, fails to lay down any intelligible standard which governs the interaction between the Competition Act and the Digital Competition Act, or to specify whether identical conduct may be subjected to simultaneous scrutiny under both the statutes. Your Lordships, in the absence of such clarity, the mere coexistence of two regulatory regimes cannot by itself be sufficient to put an undertaking on notice of duplicative enforcement.
Have you challenged the legislation? You don't challenge the legislation.
Certainly, Your Lordships, till this point we have not challenged the legislation behind, but Your Lordships, in order for the parallel proceedings to be applicable, these two prerequisites have to be fulfilled.
The intent of digital competition bill is what? Is to ensure that you don't have a practice in the future.
Certainly, Your Lordships, the ex ante.
And the intent of competition is to attract past practices that you've done.
Certainly, Your Lordship.
Where are you drawing parallel proceedings from?
Your Lordships, the reason why we are saying that it's a parallel proceeding is because it is coming from the same substratum of conduct, the same substratum of facts which is happening. And under this is where the reliance on recourse essay judgment is important. They say that in order for parallel proceedings to be allowed, foreseeability and proportionality has to be met. And I'll also fulfill to you how the item test in the principle of Nevis and idle is met. Your Lordship, both the orders, that is, both the show cause notice as well as the orders, the point of inquiry of the CCI has been the restrictive access of Orion AI as well as Immunoplus. Whenever there are both the acts questioning the same thing, we contend that these parallel proceedings are then not allowed because these two prerequisites are not fulfilled, Your Lordships. And if I could just refer to ask the Lordships to kindly refer to Article 38 of the Digital Markets Act and Article 19 of the Digital Markets Act. I have provided a copy to the Lordships. I'll summarize in brief. Both of these particular articles establish the point of foreseeability, Your Lordships. Article 38 tells about an institutional coordination architecture, whereas Article 19 talks about in conducting a market investigation, the commissioner shall take into account any relevant findings or proceedings under Article 101 and 102 of the TFU concerning digital markets as well as any other relevant developments. What we see from both of these articles, Your Lordships, is that there is inherently a coordination between the various infrastructure of law. This is something which is explicitly mentioned in the Digital Markets Act, and therefore Meta and Apple could have foreseen such parallel proceedings. In this particular case, Your Lordships, the ITCA do not have any parallel corollary provisions in the very first place, which defeats the point of foreseeability, Your Lordships. And lastly, Your Lordships, on the point of proportionality, how even that is not met, Your Lordships. It is humbly submitted that the moment the doctrine of proportionality is violated, it results in manifestly excessive penal consequences, and parallel proceedings are therefore not allowed. The adjudicating authority is obliged to calibrate penalties in a manner that is neither excessive nor duplicative. However, in this particular case, Your Lordships,
has a fine been assessed against you at this stage of the proceedings?
Your Lordships, I would disagree to that. It's just 10% on one side which has been imposed on us, and the other, a show cause notice has been given.
Right.
Certainly.
The whole case being made is you are prematurely before this tribunal, and a reasonable tribunal would factor in the earlier assessment and penalty in coming to its conclusion, essentially following your own logic on foreseeability and proportionality.
Certainly, Your Lordships, I get your argument, but the contention here is that even before the show cause notice was given, there has been a host of judgments wherein it has been laid down that earlier sanctions or earlier decisions on the same conduct of the entity has to be kept in mind before deciding on the sanction or the penalty which is being granted.
Not right, because in tax laws you have every assessment year is a different year. In one assessment year on the same conduct, the same agreement, the same practice, I can give you a relief, but I can target is the next assessment year.
Certainly, Your Lordships, but in this particular case, Your Lordships, it exactly proves my point. Here it is happening in different time periods. However, in this particular case, there is no particular change in the time period. It is the same conduct which is taking place at one point in time, which is just being characteristically changed through the interpretation. The conduct remains the same. The substratum of facts remains that there has been some amount of alleged restriction of the access of Orion AI and Immunoplus. And based on that are two disproportionate sanctions being imposed, Your Lordships, and henceforth they are disproportionate. Your Lordships, the last contention of the council, if you could kindly allow, Your Lordships. Lordships, the second penalty should duly account ensuring that the overall burden remains proportionate to the seriousness of the offence, which means that the subsequent proceedings under the ITCA should rather, in this particular case, an independent penalty is being imposed, which automatically proposes an excessive burden on an entity like Astrius and would rather create a precedent in the larger market of AI in healthcare, since it's a nascent market, and when such more competitors or more actors come up into this market, they will also be subject to the same disproportionate kind of burden or a double burden under parallel proceedings which Astrius had to face. And therefore, your lordships, the
point from what Prakash said, assuming for a moment that the behavioral and structural remedies that have been given to you by the CCI, if you implement them, give that account to the CCI has the power to drop these proceedings.
I couldn't get your question.
Assuming that you comply with all of the behavioral and structural remedies of the CCI that the CCI has laid down in the earlier order.
Certainly.
To comply with those behavioral and structural remedies,
Your,
give an account of it to the CCI has the power to drop them.
Your lordships, the question on behavioral and structural remedies is something which is on a different tangent than the remedies which we are mentioning under the ITCA.
This is the same conduct, the same practice.
Certainly, your lordships, I'll get you that. Even though there has been structural and behavioral remedies, the determinative factor behind that has already been argued by the co-counsel. And rather, even though we provide in arguendo, if this bench feels that structural and behavioral remedies should be imposed along with the 10% fine, on the global turnover, we feel that the excessive burden is what challenges the factor of proportionality, your lordship, which is again under the ITCA, and therefore the parallel proceedings are vitiated, your lordship. If the lordships are satisfied with the arguments under issue 3 and 4, the council seeks permission to proceed with the threat. Should I recite the threat, wishes? Much obliged, your lordships. Wherefore, in the light of the facts presented, the issues raised, the arguments advanced, and the authorities cited, the counsels for the respondents humbly pray before this honourable court that may be pleased to adjudge and declare that firstly, the judgment of the Honourable NCLAT, setting aside the findings and directions issued by the CCI, is liable to be set aside. Secondly, that the CCI lacks the jurisdictional authority under section 27 of the ICA to direct compulsory access to Orion AI and to mandate licensing of ImmunoPlus. Thirdly, the proceedings in case number 2 are vitiated by procedural impropriety and violation of the principles of natural justice, and consequently, section 3, subsection 3 of the ICA is inapplicable to the joint operation agreement. Fourthly, the judgment of the Honourable Division Bench of the High Court declaring notification number 15 of 2025 as ultra-virus, the patent statute, and unconstitutional is liable to be upheld. And lastly, the initiation of parallel proceedings and the imposition of penalties under both the ICA and the ITCA are impermissible in the present case, being contrary to the principle of proportionality and the doctrine of medicinality, and pass any other order, direction, or relief that may deem fit in the interest of justice, equity, fairness, and good conscience. For this act of kindness of your lordships, the respondents shall duty bound forever praise. It was an honor submitting before this court.
Can you read your first prayer again?
Certainly, your lordships. The first prayer was, the judgment of the Honourable NCLAT setting aside the findings and directions issued by the Competition Commission of Indonesia is liable to be set aside. Certainly, much obliged.
Greetings. I have the following 9 points of rebuttal. On the first issue, the point of rebuttal is that the respondents argue that the relevant market was too narrowly defined and that traditional methods of drug discovery should also be included. However, paragraph 18, the last 2 lines specifically say, in the global context, firms use GI platforms to suggest novel molecules and reduce discovery timelines in ways that were previously infeasible to traditional methods. Now, if those were infeasible to traditional methods, it is unclear how traditional methods could be clubbed with AI models in the relevant market for drug discovery. Secondly, they argued that prejudice was caused because a redacted version of commitment application was supplied to them. However, the allegation of violation of the Competition Act arises from the contract that they signed with Asturias, of which of course they had the full copy and not from the commitment application, and therefore there is no prejudice that was caused to them. Thirdly, it was argued that pro-competitive effects were there of the joint venture agreement. Your Honours, the drug was discovered by Asturias in isolation and was manufactured by them in isolation. It is unclear how the joint operation agreement helped in increasing innovation in the market or in making supply of drug more accessible. Your Honours, the case cited by them to distinguish L. Kumar is a division bench judgment and therefore cannot override a constitutional bench decision L. Kumar. On the argument on Article 14, Your Honours, Section 51 gives unbridled powers to a central government to amend Schedule 1. It is not open for the respondents to rely on a market study conducted by the CCI to argue that this power given under the legislation has to be curtailed. On argument under Article 19(1)(g), the only argument proposed by the respondents was that it will stifle innovation and development. Your Honours, these are not the thresholds of judicial inquiry when the court inquires whether an Article 19(1)(g) violation has happened or not. It must be established that the restrictions are either unreasonable or are not in the interest of the general public. Your Honours, it is unclear in the argument on Article 14 if they argue that it is 30 seconds, Your Honours. If they argue that it is under-inclusive and so should include all AI sectors, or if it is over-inclusive and so should exclude AI in healthcare. As Your Honours pointed out, it is unclear which two sectors are being treated unequally, therefore giving rise to an Article 14 violation. On the last issue, Your Honours, on simultaneous operation of penalties, recently in the case of WhatsApp versus CCI, the Delhi High Court has held that the privacy policy of WhatsApp itself, a single policy paper, can give rise to individual parallel proceedings which are right now proceeding before the Honorable Supreme Court and the Competition Commission in parallel, arising out of the same factual matrix by the same parties merely because the ingredients of both the inquiries are different, and so I would want that to be distinguished by the learned counsel for the respondents. It was a pleasure.
Clerical mistake which had taken place on my part on the part of the prayer. It was meant to uphold the judgment of the MCLAT and set aside the CCI's findings, which we are asked to reiterate. And secondly, Your Lordships, the reliance was, with regards to the Sir rebuttals, the reliance was placed on the JOA, was never disclosed to the PSA in the first place, and henceforth a proper opportunity was never provided. And secondly, the pro-competitive factors are of this nature. Firstly, that there is benefit to consumers by increasing the ultimate production of the final drug within the endosier market, and secondly, there is improvement of production and also taking place in the same context above, right? Now, moving on, Your Lordships, the L. Chandrakumar judgment also kept this in mind that the Article 226 of the writ petition was a basic structure, and it itself had recognized that writ petitions would be applicable whenever there are fundamental rights being questioned and ultra-vires of the particular legislation is being questioned. The very reason, and this particular point was conveniently omitted by opposing counsel. And lastly, with respect to Article 19(1)(g), how the judicial inquiry does not exist to innovation, Your Lordships, the wordings of Article 19 Clause 6, which provides us the reasonable restrictions for Article 19(1)(g), talks about public interest, Your Lordships. In this regard, public interest is something which will be beneficial when there is innovation and development in such a market as that of healthcare, which affects larger consumers and the daily populace on a daily basis, Your Lordships. Much obliged.
It is my proud privilege and luxury to welcome you all to the Valedictory ceremony of the 8th TNNLU-CCI National Antitrust Moot Competition 2026. Over the past few weeks, we have witnessed exceptional advocacy, sharp legal arguments, and a deep passion for law. Today, as we come to the end of this journey, we gather to celebrate the spirit of this competition and honor the efforts of every team that participated. Before we begin, let us raise for the Tamil timeout.
கடலும் one and all gathered here. On behalf of the Moot Court Committee MCC, as well as the Center for Competition Law CCL, Tamil Nadu National Law University, Tiruchirappalli, I would like to first of all welcome all the esteemed guests on the dais, starting from Sivakumar sir, Anand Bhushan sir, Prakash, Mishra sir, Somashekhar sir, Prashant sir, as well as our beloved Registrar Professor Valedictory sir. I would also like to welcome the top 4 teams who have participated in this moot, because originally there was around 70 participations. This is the largest type of CCI moot we have been connected. We have been doing this moot since 2017, but this time overall we saw around 70 participations. So the top 4 teams who have participated today, who are present in the campus, we welcome you all. We would also like to welcome all the members of the Moot Court Committee, as well as the Center for Competition Law, as well as the members who are recently selected to the Moot Court Society, and all of the students from TNNLU, both from the UG as well as the PG batches, who have gathered here on a Saturday to witness the final rounds as well as the event. So I want to also thank at the very beginning Competition Commission of India, because this is a very long-standing association we have with it. It is a successful 8th time we have conducted a Moot Court in association. They are both our title sponsors as well as the prize money sponsors for this particular competition. I would also like to thank Prashant Shivadass very specifically, because this is our first association with this law firm. In fact, the idea for this moot proposition came from Prashant sir. We had a discussion with them in a meeting. So we were brainstorming certain kind of ideas like what to write, what not to write. So when we were both discussing in the meeting, was this idea that the problem should be a little bit complex. It should not just deal with one issue. So if any of the participants felt the problem was a little complex or too many questions, part of it is also due to Prashant sir. It was his idea. So that's how we included multiple interfaces also. So this is the first time we are collaborating with them formally. So we hope like in the future also we will be having multiple collaborations with Shivadass Shivadass Law Chambers. So they are our intellectual sponsors. I would also like to specifically mention the other 3 drafting members in absentia here, especially from the Shivadass and Shivadass Law Firm. I'll please read out the names also. You would have already seen it in the Moot Court proposition. So this is a combined work along with myself from Shivadass and Shivadass Law Firm. We had 3 associates. Their name is Mr. Prahalad Sriram, as well as Mrs. Sandra Lisa Philip and Miss Ananya K. So it was a combined effect of all the 4 members, and brainstorming with them we created this kind of problem. So I would also like to welcome them in absence here. I would also like to welcome in absentia our Vice Chancellor Professor Nadu sir. So with this part, I thank you once again for each and every one of the judges, both on the dais as well as the other members for coming to this competition. Thank you once again.
Professor Dr. Somashekhar, Professor of Economics at the National Law School of India, University, Bengaluru. Prakash Mishra, Advisor Law at the Competition Commission of India.
He is a Fulbright scholar and a highly respected legal leader. Sir, we welcome you to address us, sir.
Hopefully my speech will be shorter than that introduction. And I've been a mooter in my young days, and I know this is the worst kind of torture. And you just want to know the results, and you're hearing a bunch of old people speak. So I'll keep this very short. I just want to recognize three groups of people here. The student body, sir. Your student body, from the way you invite the judges, the way you coordinate, the way you take care of the people, it's outstanding. That's why we can't do professors like Mohammed Azad, who was, I remember when he was in his 19 years, 18 years in my office the first time, right? 19 years, your final year, I think you were so fantastic. So the second group of people is, we had interactions only in the finals. I mean, all my co-judges will say, the difference is only 1 or 2 marks. You know, it was so hard to pin a victory. You guys were absolutely fantastic. I'll just give some direct feedback. You know, both teams, the way you could articulate issues, the way you paced yourselves, I mean, there was some intense questioning, right? I mean, you were overlapping questioning, and sometimes you handle yourself fantastically under fire. Fantastic. I will just give 2 feedback for future improvement. I mean, you guys were the best of the best. I've done many moots in my day. I mean, you guys are the top teams I've seen in some time. 2 feedbacks. One is, especially when you're doing rebuttals, right? Human nature is you want to go in for the kill. You want to go in for the jugular. We saw that passion, right? But sometimes less is more. Because you have 2 minutes, 9 points in 2 minutes will not translate. And that goes for many of the arguments, less is more. For the responding team, again, outstanding. The questioning was non-stop. From the time you all took the podium, speaker 1 and speaker 2, it was relentless, right? But again, fantastic job under fire. I'll give you one direct feedback. You know how the mood is, right? One is a strong problem, one is a weak problem. It is, everyone's aware. Don't get bogged down in that weaker issue, right? Find a way to sneak off to your strengths, right? And that's a better way to play rather than defend the indefensible. But otherwise, phenomenal guys, hats off to you all and the student body and the teacher community. Fantastic work.
Thanks a lot for the token of appreciation, sir. Means a lot for us. Next, I invite Mr. V.D. Sivakumar, partner at Dua Associates. He practices in the area of indirect taxation, corporate and commercial law, real estate, and the emerging field of insolvency and bankruptcy in India. He is also a regular speaker on indirect tax issues at seminars organized by the Hindustan Chamber of Commerce, the Indirect Taxes Bar Association, the Revenue Bar Association, and other reputed organizations. We are especially grateful for his unwavering support as he also raised the 2nd TNNL National Insolvency Moot Court Competition as a judge. We are so happy to have you again, sir.
Members of the faculty, my fellow judges, the organizing committee, students, participants, good evening. As was mentioned, I think this is probably the 4th or 5th moot court I'm judging over the last few years. And every time when I walk out of these doors, I keep telling myself I'm not going to see a better performance. And I'm happy to say that every time I'm proved wrong. Today too, the performances were exhilarating. And I can assure you it was as nerve-wracking for the judges as it was for the participants, because the quality was so high. Well, I really mean this. The quality of performance was really high. I don't know if this is cognitive bias because I've been practicing from 1992. I'm very old, practically a fossil. So I only know litigation practice because we didn't have the kind of options which you have today, and it's fantastic that you do. But I really do want to see all these participants who've taken place in these moot courts come into litigation practice. There's plenty of scope. We need bright young talents like you. The law like the moon, especially litigation practice, is a hard mistress. The first few years are tough, but I can assure you the results are exhilarating. So I hope to see all of you in court, hopefully, given the standards today, hopefully not arguing against me, but I hope to see you guys arguing in court soon. Good luck for the future. Thank you once again for inviting me.
Thank you so much, sir. And also thanks a lot for calling us your home far away from home, sir. It means a lot to us. leading the valedictory.
Thank you, sir. We have a flight, sir. Thank you, sir. Thank you. See you. Please be seated. What is it? Why is standing? Why is standing? Yeah.
Somashekhar, Professor of Economics at the National Law School of India, University, Bengaluru. With over 20 years of rich experience in teaching economics and law.
I didn't know I had to address you all. I did a lot of addressing yesterday. So I'll keep this short. I really enjoyed the way in which you lead your positions. I enjoyed it, and also I just enjoyed the questions that were being asked as well. Congratulations to both the teams. I wish you all the best in the future.
Thank you so much, sir. Then I request Mr. Prakash, advocate and partner at Shivadass Shivadass Law Chambers, Bengaluru. He holds a distinction degree in competition law from Queen Mary University of London and is a respected practitioner with expertise in antitrust, taxation, corporate laws, data protection, and early data. He advises a wide range of clients, including Fortune 500 companies, Indian multinationals, PSUs, and startups, and has appeared in numerous matters before the Supreme Court, various high courts, and tribunals across India. Notably, he is empaneled as an advocate for the Competition Commission of India since 2024. It is pertinent to mention that his generous contribution and constant encouragement have been one of the main reasons this event has come to life so successfully. Ladies and gentlemen, please welcome Mr. Prakash Shivadass.
Thank you. Distinguished faculty members, ladies and gentlemen, this is my fourth time at TNNLU. I've come here a couple of times before, and I echo what my brother judges have said. I think the quality has consistently gone up since pre-COVID to what it is now. It was at my invitation that Professor Azad also took up the responsibility. Round of applause to Professor Azad. Extraordinarily proud and lucky that this kind of a professor with this knowledge in a field of law addresses you on competition law, and there is a future that you can see in competition law. All thanks to him. The quality of the Moot proposition, although my team would have assisted him, I think it's entirely to him and his credit the way he has put the proposition across. That's one. And two, I think he has led the team of all of these young folks who have drafted the bench memorial. Now the bench memorial generally is 2 to 3 pages that we all receive. This bench memorial was longer than a lot of the petitions that we find in courts. But very well drafted bench memorial, excellent, pointed, crisp, short points with case laws. It's a good summary for all of us also to understand and learn how case laws have evolved over time. So congratulations to all of you, the organizing committee, two things, not as a feedback. Again, I echo what Mr. Sivakumar said. Both of you, all 6 of you rather, or hopefully all 17 teams, 17 to 3, the number of teams that have participated, I encourage all of you to come to litigation. We are in dearth of good litigating counsels across courts. We are in dearth of good skills in litigation in courts. These skills that you've sort of established here, you should carry them on when you come into courts. Defer your monetary related issues that you have against litigation. I'm a live example, and I'm sure Mr. Sivakumar is a live example of how far litigation can take you in life. So look at that as a thought process. Litigation is the only thing. I was also talking to Professor here. Litigation is the only field that will be kept away from both AI and foreign law firms coming into India. So your vocal talent is the only talent that will carry you through when you are addressing a court, and no judge is going to be replaced by an AI tool or an AI module. So it is going to be a human interface at the end of the day, and that is only going to carry you forward with this kind of skills that you have. Congratulations to both the teams. Please participate continuously. It doesn't matter if you win or lose. Please participate in proceedings as much as you can. You will learn the law and the craft a little more. Detail yourself a little bit more. Read your briefs a lot more. A lot of the questions that we have asked, answers were in the brief itself. So start reading your briefs over and over again. There are pointed questions from the brief that you can answer immediately. So keep all of these things in mind. All the very best.
Thanks a lot for inspiring us on litigation, sir. It's very rare these days to get inspired about litigation. Now we have Shri Prakash Mishra, sir, Advisor Law at the Competition Commission of India. With his deep involvement in competition law enforcement, policy and advocacy at the CCI, he brings insight from the regulatory perspective. As the title sponsor of this competition, CCI has been instrumental in making this event possible, and we are deeply grateful for the constant support and engagement. We welcome you, sir.
Good evening, everyone. I thank and congratulate the organizing committee of this moot court competition, particularly Dr. Prof. Azad. The star sir is here. Thank you very much, sir, for making this successful event possible. In CCI, it is our commitment to reach to the stakeholders through these advocacy events and reaching the hearing minds and through these moot courts is really a wonderful experience, and CCI is happy to be associated with the Nadu University for conducting these events, and congratulations to the participants. They were very well prepared, making the job of the judge very difficult to decide as to who is more prepared amongst the well prepared ones. So competing in such events in itself is an achievement. So who is the winner or who is the runner-up, that is a different thing. Participation itself is an achievement, so you are very competent, lucky to be here participating in the event. So congratulations to all of you. And once again, I thank the organizers, the star sir and Mr. Raja and his committee, the volunteers who have been taking care of all of us since so many days for making this successful event possible. Thank you very much.
Indeed, participation in itself is supreme, sir. After all the late nights that participants spend over. We will now have the event report presented by the co-convener of the moot court committee, Mr. Hari Venkatesh.
Good evening, everyone. I am Hari Venkatesh, co-convener of the moot court committee. So I am here to read out the report of the 8th TNNLU-CCI National Antitrust Moot Court competition. So this edition has been organized in association with the Competition Commission of India and in collaboration with Shivadass Law Chambers. And the moot proposition has been drafted by Mr. Prahlad, Ms. Ananya, Ms. Sandra, along with our faculty, Mr. Mohammed Azad, Assistant Professor of Law. And we had a overall registration of 75 teams for the memo elimination rounds. After a rigorous memo evaluation, we have shortlisted 24 teams for the next round. The results test of the competition happened on 3rd April 2026, and the overall rounds, which is preliminary and quarterfinal rounds, happened on 4th April 2026. Out of from these two rounds, we have shortlisted 4 teams for the semi-finals, which happened today. And the semi-finals has been judged by Mr. K.P. Anand, Joint Director Law, Competition Commission of India; Ms. Savitri Gopulai Koye, Joint Director Economics, Competition Commission of India; Mr. Bharadwaj Ramasubramanian, our partner, Unity Law; Mr. Mohammed Azad, Assistant Professor of Law in Tamil Nadu National University; Dr. Anish V. Pillai, Associate Professor of Law, School of Legal Studies, Cochin University of Science and Technology; and Mr. A. Tamilvanan, Additional Government Leader of Puducherry and High Court of Madras. And the final round has been happened after post-lunch, which has been judged by Mr. Prakash Mishra, Advisor Law, Competition Commission of India; Professor Dr. T.S. Somashekhar, Professor of Economics and Law, Tamil Nadu Law School of India University; and Mr. V.V. Sivakumar, Partner, Law Associates, Chennai; and Mr. G.V. Anand Bhushan, Founder, Partner, Bhushan Rajaram Association Consultants; and Mr. Prashant Shivadass, who is our sponsor, from Partner Shivadass Law Chambers. And I know you guys will be eagerly waiting for the results, so I don't want to take much of your time. I hope you had an enriching experience. Thank you.
Thank you so much for the comprehensive overview, Hari. Ladies and gentlemen, thank you so much for your patience. That brings us to the most awaited moment of the evening. declaration of results. I now request Mr. Vikram, finally a member of the Moot Court Committee, to come forward and declare the results of 8th TNNLU-CCI Antitrust Moot Court Competition.
Good evening, everybody. Without wasting any time, the Best Speaker Award goes to TC67, Speaker 1, Yesha Sikha from OP Jindal University. She's not here at the moment. The Best Researcher Award goes to R60, Divyanshu from Nadu University. I request some papers to mention the details of Best Researcher. The Best Memorial Award goes to TC46, Chanakya National Law University, and they're not present at the moment, goes to Abhishek Anand, Vaishnavi Kunal, and Dhananjay Kumar Mishra. The winners of the 8th TNNLU-CCI National Antitrust Moot Court Competition 2026 goes to TC60. All of you.
Academicians first, please. Yes.
The runners-up of the 8th TNNLU-CCI National Antitrust Moot Court Competition 2026 goes to TC04, Nirma University.
Congratulations. Very well. Very nice. Yes, please, please.
Announcement, Vikram, and thank you so much. Now I invite the convener of the Moot Court Committee, Mr. Prakash Ramna, to deliver the vote of thanks.
Good evening, everybody. It gives me immense pleasure to deliver the vote of thanks of the 8th TNNLU-CCI National Antitrust Moot Court Competition 2026. First and foremost, on behalf of TNNLU, I extend my sincere gratitude to the Competition Commission of India for their continued support and across multiple editions of this competition. We are especially grateful to Mishra, Savitri ma'am, and KP Anand sir for taking out the time to be with us today. We truly appreciate it, sir. I would also like to extend my heartfelt gratitude to Prakash sir and the entire team at Shivadass Shivadass Law Chambers. We truly appreciate it. Thank you very much, sir. In fact, the genesis of the collaboration began with a simple phone call to Prakash sir and from there, over the past few months, the way in which their team collaborated with us was seamless, and they helped us at every stage. Their generous support, both in terms of time and resources, have been absolutely critical in the way that we conducted the competition. It helped us ensure that the competition went on in such high standards. We truly appreciate it, sir. The proposition that shaped this competition is a result of countless hours of effort and careful thought of the team at Shivadass and Shivadass, and we are deeply grateful for their time and energy that the team invested in. Convey our regards to Nitya and the team at Shivadass and Shivadass. Thank you very much, sir. We are also grateful to Sivakumar sir for graciously agreeing to judge the competition at a very short notice. It means a lot to us, sir, that you could join us. Thank you for coming back to the campus. Similarly, sincere thanks to Anand Bhushan sir for his consistent support. Despite an incredibly demanding schedule, sir just landed from the United States yesterday evening and he made some time to come to the event. It means a lot. Thank you very much, sir. We would also like to extend our sincere thanks to Prof. Somashekhar for not only judging the competition but also for engaging the students for the past couple of days. It means a lot that people like you, senior academicians, take out the time to come to our university, interact with students. It means a lot to us, sir. Thank you very much. Of course, we also like to place on record our gratitude to the Vice Chancellor, the Registrar, University Administration, and the support staff for all the effort that goes behind the scenes to make the event possible. Next, I would like to place on record the gratitude to the faculty in charge of the Moot Court Committee, Mr. Mohammad Azad and Ms. Mishra, for their constant support. Special thanks to Valedictory Parinam as well for being with us throughout and always stepping in whenever we needed her help. And finally, to my team, honestly, you are the pillars of the competition. A simple thank you to not capture the effort and time that you all have put in. From managing over 75 teams to setting up and running 12 court halls, to coordinating with judges across the country, it would not have been possible without your time and dedication. I am incredibly proud of the effort that you have put in. Please keep up the good work. And a huge thank you to all the participating teams. We hope you had a rewarding experience. We look forward to welcoming you in our future editions as well. If I have inadvertently missed mentioning anybody, please accept my sincere apologies. It was certainly not intentional. Thank you very much.